The first time I heard the word completed, I was standing near the old cattle gate, with frost still clinging to the grass and my boots sinking slightly into the mud my grandfather used to complain about every winter. The air smelled like damp earth and diesel drifting in from the main road. Nothing about the morning suggested finality, which made the sentence feel misplaced. "The sale is completed," my mother said, loud enough for the farmhand repairing the fence to hear. "The buyers transferred the balance yesterday. It's done." My father stood beside her, hands in his coat pockets, eyes fixed somewhere beyond me, as if this were weather, inevitable, and already moving on. Behind them, a man in a charcoal overcoat held a leather folder and checked his watch. Like this land was already an appointment he had mentally crossed off. I didn't raise my voice. I didn't ask why, in a broken tone. I simply looked at my mother and said evenly, "Completed under what authority?" Her mouth tightened slightly. "Under ours," she replied. "Your grandfather left us the farm. We didn't need permission to sell it." My stomach tightened, but my voice stayed level. "If that were true," I said, "the probate would be closed." My father finally looked directly at me. "Your grandfather died 2 years ago," he said. "The land doesn't belong to ghosts." "It belongs to estates," I replied, "and estates require grants." My mother exhaled softly, as though patience itself were running thin. "Listen to her," she said to the man with the folder, as if I were a minor inconvenience, always acting like she's cross-examining someone. I turned to him. "Who are you?" I asked. He hesitated, then offered a polite, practiced expression. "Julian Beck," he said. "Hearthfield Developments. We're looking forward to bringing some structure back to the property." He said it like he was doing us a favor. My father pulled a folded set of papers from his coat and pressed them toward me. "Sign this," he said. "Just an acknowledgement." I didn't take them immediately. I let the pages hover between us. "Sign what?" I asked calmly. "A consent confirmation," my mother said quickly. "It simply states you won't interfere. It's procedural." Procedural. The word settled badly. "You don't own anything here," my father added. "This keeps things smooth." My throat tightened, not because I believed him, but because I remembered my grandfather sitting at the kitchen table one evening, tapping a manila envelope against the wood. "People get reckless when land becomes leverage," he had said. "They assume whoever speaks first controls the story." At the time, I thought he meant neighbors. I didn't think he meant my parents. I looked past them, toward the farmhouse, toward the oak tree he refused to cut down, toward the barn roof. He repaired himself long after he should have stopped climbing ladders. Then I looked back at my mother. "I'm not signing anything at a gate," I said evenly. "If this sale is legitimate, it will survive daylight and records." My father's face flushed. "Don't do this, Eleanor." He rarely used my full name unless he wanted it to sound like authority. "Do what?" I asked. "Ask for the file number?" Julian Beck cleared his throat. "The transfer has already been registered," he said. "We've scheduled a survey team. Work begins shortly." "Registered where?" I asked calmly. My mother's eyes flicked just once. "That doesn't matter," my father snapped. "It does," I said. "If title has transferred, it's recorded somewhere. If it isn't recorded, it isn't real." My mother smiled faintly. "Go and check," she said. "You'll realize you're mistaken." My father pushed the papers closer. "Sign and stop delaying the inevitable." I took the documents then, not to agree, but because paper carries fingerprints and ink carries timelines. I scanned the first page and felt my stomach go cold for a clean, practical reason. There was no probate reference, no grant number, no land registry instrument code, just a vague consent paragraph and a space for my signature. It wasn't a document meant to protect anyone. It was a document meant to silence me. I handed it back. "No," I said. My father's eyes hardened. "Then you can watch the bulldozers arrive," he said. loud enough for the farmhand to hear. My mother stepped closer, lowering her voice. "You always need to feel important," she whispered. "This is why you end up on the outside." I didn't respond. I didn't give her what she wanted. I turned, walked to my car, and drove away without slamming the door or spinning gravel, because the place that mattered now wasn't the field or the barn. It was the county offices. 40 minutes later, I parked outside the Devon County Land Registry and Records Office. The building smelled faintly of toner and old paper. A sign near the entrance read, "All records are public. Good." I approached the counter and waited until the clerk looked up. She was middle-aged, glasses resting low on her nose, expression neutral in the way of someone who had seen too many families argue over paper. "I need the title history for the Rowland farm parcel," I said, "and the probate file for my grandfather, Arthur Rowland." Her eyes flicked up. "Address?" she asked. I gave it. The keyboard clicks sounded too loud in the quiet room. Her eyes tracked the screen. Then she paused. Not the pause of someone searching, the pause of someone noticing something that didn't align. She leaned closer. "What's your name?" she asked. "Eleanor Rowland." "And your relationship to Arthur Rowland?" "Granddaughter." She nodded once. One moment. She disappeared toward the back shelves. When she returned, she didn't bring a thick ledger. She brought a thin folder and placed it on the counter like it carried more weight than paper. "There's a recent transfer," she said. My pulse didn't spike. It narrowed. "Recorded?" I asked. "Yes," she replied. "Recorded yesterday." Yesterday. While I was at work. While my phone was silent. While my parents were already celebrating. "Can you print the last 2 recorded instruments?" I asked calmly. "With the instrument numbers and grantor details?" She nodded and began printing. The machine hummed, then produced 2 stamped pages. She slid them toward me. Hearthfield Developments was listed clearly, but the grantor line made my stomach tighten. It didn't list my parents. It listed estate of Arthur Rowland. I kept my face still. "That's an estate transfer," I said quietly. "Where's the probate case?" The clerk clicked again. "That's the issue?" she said. "What issue?" I asked. "There's no active probate file under Arthur Rowland," she said slowly. "No grant recorded here." My hands felt cold. Not panic. Clarity. "So how was the estate property transferred?" I asked. She stared at the screen again. Scrolled, then stopped. "There's an attached packet," she said. "Scan document." She clicked once. A small window opened. The label read, "Deposited will packet." Her posture changed. She leaned closer to the monitor, then toward me, lowering her voice. "This was never admitted," she whispered, "and it changes who owns the land." For a moment, I didn't move. Not because I didn't understand, but because I did. If there was a will sitting in a deposited packet that had never been filed, then my parents hadn't just sold land. They had outrun the truth. "Print it," I said evenly. "Certified copy, if possible." She hesitated. "I can print what's scanned," she said carefully, "but I can't give advice." "I'm not asking for advice," I replied. "I'm asking for records." She nodded once, then clicked into another panel. "Before I print," she said quietly, "I need to check whether this packet was accessed recently." My chest tightened. "Why?" I asked. "Because when something dormant suddenly appears attached to a transfer," she said, "it usually means someone knew it existed." She scrolled. Her eyes narrowed. Then she stopped. "It was opened yesterday," she said softly. "By who?" I asked. She clicked again. A name populated. Margaret Rowland. Time-stamped less than an hour before the transfer was recorded. My voice stayed steady. "So she was here?" I said. The clerk nodded once. "And she still proceeded," I said. She didn't answer. "I'm going to get my supervisor," she said, "because this isn't routine." She disappeared through a back door, leaving me standing at the counter with 2 stamped instruments, and the quiet certainty that nothing at the farm gate had been accidental. The supervisor arrived without haste, which told me more than any apology would have. He was tall, gray-haired, and dressed in a way that suggested he spent most of his days mediating disputes that began long before they reached his desk. His name badge read, Jonathan Pierce. He glanced at the 2 printed instruments in my hands before looking at the clerk. Which parcel? He asked. She gave the reference number. He nodded once and turned his attention to the screen. He didn't speak while he read. He scrolled slowly, deliberately, as though speed would cheapen whatever conclusion he was about to reach. When he finally looked up, his expression didn't change, but the room felt tighter. You're Eleanor Rowland, he said. Yes. And Arthur Rowland was your grandfather? Yes. He tapped the desk lightly. There's a recorded transfer from the estate to Hearthfield Developments, but there's no grant of probate attached to authorized disposition. That's what I was told, I said. Jonathan Pierce leaned back slightly. Then the question isn't whether the transfer was recorded, it's how. He nodded to the clerk. Open the attachment history. She did. A small panel appeared on the screen, lines of access data stacked neatly in a way that felt almost accusatory. Dates, times, user IDs. Jonathan leaned closer. This deposited will packet, he said. It was accessed yesterday morning. Yes, the clerk replied. By Margaret Rowland. Jonathan's mouth tightened. And the affidavit? Submitted less than an hour later. He exhaled once through his nose, then straightened. That sequence matters. He turned to me. A deposited will is not a public filing, he said. It's held for safekeeping. It doesn't grant authority by itself, but it does prevent people from truthfully swearing. There is no will. My voice stayed calm. So, the affidavit was false. Jonathan didn't answer directly. He turned back to the clerk. Print the affidavit, the access log, and the submission receipt. Certified. The clerk nodded and moved toward the printer. Jonathan looked at me again. Have you contacted legal counsel? Not yet, I said. I wanted records first. That was the right order, he replied. While the printer worked, Jonathan explained what the screen already showed. The affidavit of authority claimed that Arthur Rowland had died intestate. It named my parents as the only heirs and asserted they had authority to convey estate property. It bore their signatures. It was notarized. On its face, it looked sufficient. But faces, I had learned, were rarely the problem. The clerk returned with the papers. Jonathan reviewed them, added his signature and stamp, and slid the packet toward me. These are certified copies, he said. They confirm what was filed, when it was filed, and who accessed the deposited will before the filing. I didn't thank him. Gratitude felt out of place. This wasn't a favor. It was process. Is there anything else I should request? I asked. Jonathan considered that. There is one more thing, he said. Copy request history. The clerk's fingers paused above the keyboard. Then she nodded and clicked into another system. A receipt appeared. Margaret Rowland. Paid at the counter. Item description. Deposited will packet copy. Date and time. Yesterday morning. Less than 30 minutes before the affidavit was submitted. I felt something settle in my chest. Not relief. Alignment. She paid for a copy, I said quietly. Yes, Jonathan replied, which makes it difficult to argue ignorance. He stood. You need to open probate immediately, he said. The court needs to appoint an executor. Until then, the recorder can only do so much. I understand, I said. Jonathan nodded. Once probate is opened, you or your solicitor can file a notice against the title. That will alert any third party searching the record. Will it stop development? I asked. It won't erase what's been recorded, he said, but it will cloud it, and developers don't like clouds. I gathered the papers and stepped away from the counter. My phone buzzed as I did. A text from my father. Don't make this ugly. The survey team is coming tomorrow. Just sign and let this move forward. That wasn't reassurance. It was a clock. I didn't respond. Instead, I walked down the corridor toward the probate office. The hallway smelled of old carpet and toner. People sat on benches clutching folders, whispering to themselves, rehearsing arguments no one would hear. When it was my turn, I slid the certified packet under the glass. "I need to file a will for probate," I said calmly, "and open an estate case today, if possible." The clerk was younger than the one at records, sharp-eyed, efficient. She flipped through the pages, stopping at the deposit stamp. "This was lodged for safekeeping," she said. "Yes." "And there's been a transfer recorded?" "Yes." "Based on an affidavit claiming there was no will." That changed her posture. Not sympathy, procedure. "Name of the deceased?" "Arthur Rowland." She typed, frowned. "No case exists." "That's why I'm here." She nodded slowly. "You'll need to submit a petition, a certified copy of the will, and details of the assets." She slid the forms under the glass. I filled them out carefully. Date of death. Known heirs. Farm parcel reference. When I reached the line marked Proposed Executor, my hand didn't hesitate. Eleanor Rowland. When I reached the question asking whether a will existed, I checked yes and wrote, "Deposited, will located, and certified copy attached." The clerk reviewed the forms. "You'll need a hearing for appointment," she said. "We can request expedited, but it depends on availability." "I need expedited," I said. "A survey crew is scheduled for tomorrow." She paused, then nodded. "We can file an emergency motion alongside the petition, but you should have representation." "I do," I said, and slid a card under the glass. Claire Whitmore. Probate and property. The clerk glanced at it and nodded once, like she recognized the name. "Filing fees," she said. I paid, the receipt printed with a small final chirp. She stamped the packet and handed me a sheet with a case number at the top. Seeing a case number beside my grandfather's name felt like gravity returning. "Now," I said calmly, "I need to notify the recorder that probate has been opened." She nodded. "Your solicitor can file a notice of probate and a notice of pending action, but once the cases live in the system, you can record the case number today." "How long until it's live?" I asked. She checked her screen. "Within the hour." She hesitated, then lowered her voice. "If that affidavit was knowingly false, the court will take that seriously." "I know," I said. I stepped aside and called Claire Whitmore. "It's filed," I said when she answered. "Case number issued, emergency motion submitted, certified copies in hand." "Good," Claire replied. "Now we move quickly. We record notices against the title and we serve the developer." "I'm still in the building," I said. "Perfect," she replied. "Go back to records with your case number. I'm emailing you the notice language now." My phone buzzed as 2 PDFs arrived. Short, precise, unforgiving. I returned to the records counter. The clerk looked up and recognized me immediately. "You opened probate," she said. "Yes," I replied. "I need to record these notices today." She reviewed the documents, checked the case number, and nodded. "Give me 10 minutes." I waited, watching people come and go, aware that every second my parents believed they were still ahead. When she returned, she slid the receipts toward me. Instrument numbers printed clearly at the top. Stamps sharp and final. "This is now in the public record," she said quietly. "Anyone searching title will see there's an active probate action." "That's enough," I said. I stepped outside and dialed the number on the development paperwork my father had tried to make me sign. "Hearthfield Developments," a receptionist answered. "My name is Eleanor Rowland," I said evenly. "The farm parcel you believe you purchased is now subject to an active probate case. A notice of pending action has been recorded. You do not have clean title." There was a pause. "One moment," she said. A man came on the line, measured, legal. "This is Simon Grant, counsel for Hearthfield," he said. "Ms. Rowland, your parents represented that they had authority." "They represented falsely," I replied calmly. "The will exists. It names me executor. The record reflects that as of this afternoon." Silence. "If that's accurate," he said carefully, "we will suspend all activity." "Put it in writing," I said. Another pause. "We will," he replied. I ended the call. The clock was still running, but now it was running against them. When I ended the call, my phone buzzed again. This time it was a message from my mother. You think paperwork stops progress? The buyers have already paid for surveys. This is happening. I read it once and locked the screen. I didn't argue with messages anymore. Messages were noise. Records were signal. I walked back toward the probate window and asked the one question that mattered now. Has the emergency motion been assigned to a judge? I asked. The clerk checked her screen. Assigned, she said, but no hearing time yet. You may receive a call. Tomorrow morning, I said quietly, mostly to myself. It was too late to rely on goodwill. I stepped into a quiet corner of the building and called Claire Whitmore again. They're still moving forward, I said. Survey crew tomorrow. Claire didn't hesitate. Then we seek a temporary restraining order, she said. Tonight, if possible. If the duty judge won't hear it tonight, we file first thing in the morning and serve notice immediately. I've spoken to the Developers Council, I said. They claim they'll pause. Developers pause, Claire replied. Families create facts on the ground, stakes, flags, signs, machinery. It's theater. I closed my eyes briefly and pictured survey markers driven into soil my grandfather had walked every morning for 40 years. Tell me what to do, I said. Go back to the farm, she said. Do not engage. Photograph everything. If anyone arrives, you calmly inform them there is an active probate case and recorded notice. If they ignore you, you contact the police. The police, I repeated. That's what it is now, she said. Property interference. I drove back as the light began to soften. The hedgerows looked unchanged, but my body didn't feel the same. My hand stayed steady on the steering wheel, but my chest held something tight and deliberate. When I turned onto the farm road, I saw the first change immediately. Thin wooden stakes lined the edge of the lower field. Bright plastic flags fluttered weakly in the wind. Survey preparation. At the gate hung a brand new sign. No trespassing property, under contract. My father stood near the gate with his arms folded, as if he had been waiting. My mother leaned against his car, her expression composed, almost pleased. You came back, my father said. Ready to sign now? I didn't raise my voice. I pulled the receipt from the recorder's office from my folder and held it up. There's an active probate case, I said evenly, and a notice of pending action recorded against the parcel. Your affidavit claiming there was no will is false. My mother's smile didn't fade. It sharpened. That won't stop tomorrow, she said softly. The survey crew is coming with police. My stomach tightened, but my voice stayed calm. The police don't escort fraud, I said. My father's eyes narrowed. Watch. My phone buzzed again. An unknown number. A voicemail notification appeared immediately, as if it had been timed. The transcript preview read, Miss Rowland, this is the county police. We have received a complaint that you are trespassing on private property. I didn't rush to respond. I stood by the gate and played the voicemail again, slowly, so my parents could hear it clearly. My father's mouth curved into a half smile. My mother's eyes stayed bright. You called the police on me, I said calmly. You're trespassing, my father replied. It's not yours anymore. I didn't argue the sentence. I argued the record. I called the number back. This is Eleanor Rowland, I said when the dispatcher answered. I received a voicemail regarding a trespass complaint. I need the incident number, reporting party, and responding officer. There was a pause. Are you on scene, Mom? The dispatcher asked. Yes. Another pause. Typing. There is a complaint logged, she said. An officer is en route. Incident number? I asked. She gave it. I repeated it back. And the reporting party? A longer pause. Margaret Rowland. I looked at my mother. Her expression didn't change, but her eyes flicked once. Thank you, I said. Please note in the call log that a probate case was filed today, and a notice of pending action has been recorded against the property. Instrument numbers are available. The dispatcher hesitated. I'll add that. I ended the call. I didn't shout. I didn't threaten. I pulled out my phone and took photographs. The sign, the stakes, a wide shot of the gate with my parents standing beside the new signage. I documented the scene the way Claire had instructed, the way investigators do. A patrol vehicle arrived 10 minutes later. Slow, controlled, gravel crunching under tires. The officer stepped out. Neutral posture, body camera centered. He looked between us. "Afternoon," he said. My father spoke first. "She's trespassing." The officer didn't look at me. He looked at his notepad. "I've got a note here about probate," he said, "and a recorded notice." "Yes," I said calmly. "The documents are available." I handed him copies. He read carefully, slowly. "This is a civil matter," he said finally. "No one is being removed tonight." My mother stepped forward. "But the land has been sold." The officer shook his head. "That's not something I decide." He turned to me. "Ma'am, if there's further disturbance, document it." He left as calmly as he arrived. The sun dipped lower. The wind moved through the fields the same way it always had. But nothing else was the same. That night, Claire filed the emergency motion with the duty judge. Not a courtroom, not a speech, an electronic filing. A quiet video hearing scheduled after hours. I joined from Claire's office. The judge appeared on screen wearing reading glasses and a loosened tie. "Explain why this can't wait," he said. Claire didn't embellish. She laid out facts, timelines, access logs, receipts, the affidavit, the stakes, the police call. When she finished, the judge didn't speak for a moment. Then he said, "I'm granting a temporary restraining order. No entry, no survey activity, no alteration pending hearing." The order was issued before midnight. By morning, everything had changed. The order was served before sunrise. Claire didn't waste time explaining it to me. She forwarded the stamped copy, then followed it with a single sentence. "It's active. Don't argue. Just document." By the time I reached the farm, the light was thin and gray, the kind that makes everything feel unfinished. Dew clung to the grass. The air was quiet in the way it gets right before people arrive believing they still have momentum. The survey trucks came just after 7. 2 white vehicles pulled onto the gravel road, bright vests visible through the windscreens. And just as my mother had promised, a marked police car followed behind them. But it wasn't an escort. It was the same officer from the night before. He parked, stepped out, and held a folded document in his hand. My father walked forward immediately, confidence already rising in his posture. My mother followed, arms folded, her expression composed, rehearsed. "The crew is here," my father said loudly. "Tell her to leave." The officer didn't look at me. He looked at the document. "I've been served an order," he said calmly. He unfolded it and held it up. "Temporary restraining order." My father's face shifted, just for a second. My mother's smile tightened. The officer read aloud, his voice carrying clearly across the gate. "No entry by any party. No survey activity. No grading, staking, or alteration of the property pending court hearing." He turned to the crew chief. "If you begin work, you will be documented violating a court order," he said. "Pack up." The crew chief didn't argue. He glanced at my parents, then back at the officer, and nodded. "We're not touching this," he said, already reaching for his phone. My mother stepped forward. "This is absurd," she snapped. "She's manipulating the court." The officer's tone didn't change. "Ma'am, you are on notice," he said. "Step back." My father's face flushed. "We already sold it," he barked. "It's not hers." The officer looked at him steadily. "Then you should have sold something you had the authority to sell," he replied. The crew began loading equipment back into the trucks. That should have been the end of it. It wasn't. My mother turned toward me, voice loud enough for everyone to hear. "Your grandfather is gone," she said. "You don't get to crown yourself ruler of land that isn't yours." I didn't raise my voice. I didn't step forward. I held up the order and the recorder's receipts. "I'm not crowning anything," I said calmly. "I'm recording." That's when my father made his mistake. He bent down, grabbed one of the survey stakes, and yanked it out of the ground, like force could undo procedure. "Enough of this," he shouted. The officer moved immediately. "Sir," he said sharply, "stop." My father didn't stop. He threw the stake into the ditch like a tantrum could become a legal argument. "Hands behind your back," the officer said. "What?" my father shouted. "For what?" "For violating a restraining order and interfering after being directed to stop." The cuffs clicked closed. The sound was small, final. My mother froze. Another police car pulled onto the road. Then another. Backup already requested. Procedure stacking on procedure. My mother tried to pivot into outrage. "He's an old man," she cried. The officer didn't blink. "He's an adult," he said, and he was warned. While my father was guided toward the car, another officer approached me. "The district attorney has requested copies of the affidavit and access logs," he said quietly. "They'll have everything," I replied. The survey trucks left. The developer never came back. The land stayed still. Later that week, probate court moved quickly. The will was admitted. The handwritten codicil was read into the record. I was appointed executor. The affidavit of authority was formally challenged. The recorded transfer was flagged. A quiet title action was initiated to unwind the conveyance. Hearthfield Development's counsel appeared calm and furious in equal measure. They withdrew, demanded restitution from my parents, and preserved their communications. In open court, the judge looked at the receipt showing my mother paid for a copy of the will. Then, at the affidavit claiming no will existed. "This is not ambiguity," he said. "This is intent." The matter was referred for prosecution. My parents walked into the hearing expecting sympathy. They walked out with arraignment dates, bond conditions, and a no-contact order barring them from the farm. Months later, the public record was corrected, the title restored, the land placed into a structure my grandfather had anticipated and approved. The fields didn't change. The winds still moved the same way through the hedges. But when I stood at the gate, I wasn't bracing for betrayal anymore. I was standing on something the law recognized as mine. The silence that followed wasn't empty. It was structured. For the first time since my grandfather died, there were no letters arriving with unfamiliar logos, no phone calls framed as updates that were really warnings, no third parties pretending to be neutral while circling the edges of something they thought would eventually be theirs. The farm existed again as a place, not a dispute. Probate moved faster than I expected once the court stopped treating the situation as a misunderstanding. The affidavit, the access logs, the receipt, and the attempted enforcement of a sale during an open dispute removed any ambiguity. Judges don't need emotion to move quickly. They need clarity. The will was admitted in full. The codicil was admitted without argument. My appointment as executor was confirmed in a short hearing that lasted less than 15 minutes. No speeches, no raised voices, just questions, answers, and a signature that shifted authority in a way no argument ever could. My parents did not attend that hearing. They were advised not to. The quiet title action unfolded on paper. Filings, responses, withdrawals. The developer's legal team submitted affidavits distancing themselves from the representations made by my parents. They preserved communications, timestamps, emails, meeting notes. They were not interested in sentiment. They were interested in survival. Their withdrawal was recorded, their claim dissolved without ceremony. The county recorder updated the public register. The fraudulent transfer was marked as contested, then voided. The notation sat there plainly for anyone to see. Not hidden, not softened, just accurate. That accuracy mattered more than anything else. The criminal case moved separately, slower, heavier, less predictable. My mother entered a plea agreement that required restitution, a permanent prohibition on representing authority over any estate or trust property, and a condition barring her from initiating contact with me outside of legal counsel. She signed it without looking up. My father fought longer. He argued confusion, misunderstanding, bad advice. None of it survived cross-checking against the access logs, the receipt, and the order he violated at the gate. Contempt is difficult to explain away once it's documented by body cameras and timestamps. He served time. Not much. Enough. Enough to understand that land doesn't bend because someone is angry at it. The no-contact order stayed in place throughout the proceedings. It was renewed once, quietly, without discussion. By then, no one objected. The court didn't frame it as punishment. It framed it as preservation. Preservation of process, preservation of property, preservation of distance. I returned to the farm gradually. At first, just to walk the boundaries with the surveyor I hired myself. A different one. One who didn't speak unless spoken to and who logged everything twice. Once digitally, once on paper, then to review the buildings, then to sit on the porch where my grandfather used to drink tea and count the minutes between passing cars. I placed the land into a protective structure before anyone could ask why. A trust, with restrictions so plain they bordered on boring. No unilateral sales, no third-party encumbrances without court oversight, no surprises disguised as urgency. My solicitor called it conservative. I called it finished. The corn still moved with the wind. The hedges still grew unevenly where the soil was stubborn. The gate still creaked in the same place it always had. But the feeling was different. Not triumphant. Settled. I didn't confront my parents after the cases concluded. There was nothing left to say that hadn't already been said in filings, orders, and recorded decisions. Conversation would have been redundant. Records are not redundant. They remain. Months later, I received one final letter from the county clerk's office. It wasn't personal. It wasn't dramatic. It simply confirmed that all contested notations had been resolved and that the public record now reflected the final probate determination without encumbrance. That sentence mattered. Public record corrected. That's how the story ended. Not with reconciliation. Not with forgiveness. With accuracy. If your family moved quietly to sell something that wasn't fully theirs, would you argue first? Or would you do what I did and go straight to the clerk, the logs and the filings that don't care who raised you? If you want more stories like this, where records matter more than shouting, subscribe. I'll see you in the next one.